5 seconds to go. Start. On the issue of admissibility of call records without there being appropriate certificate under section 65b(4) of the Evidence Act, a bench of 2 judges of this court in State NCT of Delhi versus Navjot Sandhu had observed. It is contended by Mr. Shanti Bhushan, appearing for the accused, that the call records relating to the cellular phone said to have been used by Shaukat have not been proved as per the requirements of law, and their genuineness is in doubt. The call records relating to the other mobile numbers related to Gilani and Afzal are also subjected to the same criticism. It is the contention of the learned counsel that, in the absence of a certificate issued under subsection 4 of section 65b of the Evidence Act with the particulars enumerated in clauses A to C, the information contained in the electronic record cannot be adduced in evidence, and in any case, in the absence of examination of a competent witness acquainted with the functioning of the computers during the relevant time and the manner in which the printouts were taken, even secondary evidence under section 63 is not admissible. The switch which is maintained in the computer in respect of each telephone receives the signal of the telephone number called or received and serves them to the server, and it is the server which keeps the record of the calls made or received. In case where the call is made and the receiver does not pick up the phone, the server which makes a loop of the route would not register it. As far as PW36 is concerned, he identified the signatures of the general manager of his company who signed Exhibit P36 series. He testified to the fact that the call details of the particular telephone numbers were contained in the relevant exhibits produced by him. It is significant to note that no suggestion was put to these two witnesses touching the authenticity of the call records or the possible tampering with the entries, although the arguments have proceeded on the lines that there could have been fabrication. In support of such argument, the duplication of entries in exhibits 36.2 and 36.3, and that there was some discrepancy relating to the cell ID and IMEI number of the handset at certain places was pointed out. The factum of presence of duplicate entries was elicited by the counsel appearing for Afsan Guru from PW36 when PW36 was in the witness box. The evidence of DW10, a technical expert, was only to the effect that it was possible to clone a SIM by means of a SIM programmer which to his knowledge was not available in Delhi or elsewhere. His evidence was only of a general nature, envisaging a theoretical possibility and not with reference to specific instances. According to section 63, secondary evidence means and includes, among other things, copies made from the original by mechanical processes which in themselves ensure the assurance of the copy, and copies compared with such copies. Section 65 enables secondary evidence of the contents of a document to be adduced if the original is of such a nature as not to be easily movable. It is not in dispute that the information contained in the call records is stored in huge servers which cannot be easily moved and produced in the court. That is what the High Court has also observed at para 276. Hence, printouts taken from the computer's servers by mechanical process and certified by a responsible official of the service providing company can be led in evidence through a witness who can identify the signatures of the certifying officer or otherwise speak of the facts based on his personal knowledge irrespective of the compliance with the requirements of section 65b, which is a provision dealing with admissibility of electronic records. There is no bar to adducing secondary evidence under the other provisions of the Evidence Act, namely section 63 and 65. It may be that the certificate containing the details in subsection 4 of section 65b is not filed in the instant case, but that does not mean that secondary evidence cannot be given even if the law permits such evidence to be given in the circumstances mentioned in the relevant provisions, namely sections 63 and 65. The learned senior counsel Mr. Shanti Bhushan then contended that the witnesses examined were no technical persons acquainted with the functioning of the computers, nor do they have personal knowledge of the details stored in the servers of the computers. We do not find substance in this argument. Both the witnesses were responsible officials of the companies concerned who deposed to the fact that they were evidence of PW35 shows that he is fairly familiar with the computer system and its output. Stop.